Good morning. Happy Monday. It seems like some people have some sort of a misunderstanding or a miscomprehension about who gets to decide what the Supreme Court means in a particular case. And the way it works is the Supreme Court is the ultimate arbiter of federal law. And federal law includes the Constitution, federal statutes and regulations and policies and all those other things, and stare decisis, case law. The Supreme Court gets to determine what case law is and what it means. They get to interpret it. And their interpretation is binding. So when the Supreme Court comes along and says the holding in Pennsylvania versus Mimms is that a police officer can, as a matter of course, without regard to officer safety or anything else, initially in Pennsylvania versus Mimms, they were discussing officer safety when they came to the conclusion that the officer could pull people out. Maryland versus Wilson, the Supreme Court says this is what we meant in Pennsylvania versus Mimms. We meant that as a matter of course, just as routine, the officer can order people out of the vehicle if they've made a lawful stop. Then that's what it means. And you could try to argue that all you want. The Supreme Court has done the interpretation for you. They've said what it means. And any interpretation that is in any way contradictory to that is invalid. Just as a matter of course, it is invalid. So do with that as you will. All the talk about officer safety that everybody's trying to do in the comment section, meaningless, absolutely meaningless. That was the initial justification for it. Great. But now, as a matter of course, an officer can pull you out of the vehicle if he's lawfully stopped you. As a matter of course, regardless of any considerations of safety or anything else, as a matter of course, the officer can pull you out. Routinely, the officer can pull you out. If he wants to, he could pull you out. That's it. Case closed. Problem solved. End of demonstration. Thanks for watching. Have a great day.